So this is Diesel for We the People. How are you? Alright, so I'm going to do a disclaimer. I am not an attorney, nor ever want to be an attorney. What we discuss on this YouTube is a learning tool. See which direction we want to go as we the people or public citizens. Now when you see my other videos, you know there's a difference between we the people and public citizens. But I've also talked about qualified immunity, absolute immunity. And you guys know how I stand if you've seen any of the videos. So this is going to help define what I was talking about. Alrighty? And I will stop the video and kind of tell you what's wrong with this picture. And for y'all to decide whether it's correct or right. Alright? Again, YouTube, this is a learning video. So that we, the people, or public citizens, understand what's going on around us. So, here we go.
Qualified immunity is a doctrine that was created by the United States Supreme Court in 1960.
Alright, just right off the top, y'all. Right off the top. Supreme Court got a doctrine. Alright? So it's not even law. That's the number one thing. Number two, Supreme Court cannot do this at all. They have no authority to do this at all. And the reason why I'm speaking this way is to really draw y'all in and really define and understand how they illegally gave themselves a qualified immunity. Okay? This is the reason why I say it's unconstitutional, because it's unconstitutional. It does not exist in the Constitution. They created a doctrine, a non-constitutional doctrine that they can not do. Number one, Supreme Courts are opinions. So when they say, oh, they did a ruling, wrong. They always make opinions. If it's constitutional, then, you know, the government officials leave it as stands. If it's unconstitutional, then it's be sent back to the government officials and they clean the unconstitutional thing up or just drop it. But there is no law of the land by the Supreme Courts. As every single ruling they've done, wink wink, is opinions. No matter what they've done in their lifetime, they cannot create law. That's Congress' job. That is your Texas representative's job. Any courts cannot create law. And this qualified immunity is what they basically did. They created law to protect themselves. So they are treating we the people and public citizens as fools. We're dum-dums. We're idiots. Alright? That is what they are saying. Proceed forward.
7. The doctrine shields government officials from liability for damages claims, even if they've violated the Constitution, if they've not violated what the Supreme Court calls clearly established law.
Alright. Again, see how that worked? Even they violate the Constitution, they still don't get punished. Because they put an umbrella around them illegally. It has to be a clearly established law. All right. For y'all out there, there is. There is a law out there. It's called 18 U.S.C. 241, 18 U.S.C. 242. There is a clearly established law. They cannot do these things, but they ignore it. Why? Because we, the people and public citizens, in their eyes, a bunch of dum-dums. Lawyers know this. UCLA or whatever they are. Now, I'm not fully involved in their deal, okay? They take things way too far out of hand, and then they also do good things. So I'm 50-50 on them. But in this instance, I really think ACL, whatever they are, is actually against this qualified immunity and should be. And I would like to see some of the paperwork when they file a lawsuit if they actually put the 18 U.S.C. 241, 242 in there. Because that's where it defines the clearly established law. Alright, I'm going to proceed forward now.
When the Supreme Court created qualified immunity,
Again, created. They had no authority. Supreme Court cannot create any laws or anything evolve around the law to protect themselves. They cannot do it. The only way they get by with it is because we, the people, and public citizens, again, are a bunch of dum-dums in their eyes.
did so in the terms of the court to protect from liability all but the plainly incompetent or those who knowingly violate someone's rights.
There's an ongoing, vigorous debate about whether qualified immunity is important for police officers to have.
There is no debate. They shouldn't have it. If they operate in the oath of upholding the Constitution, there is no debate. If people decide to sue them because they destroyed the Constitution, well, one or two things is going to happen. You, the officer, should, in fact, go in front of a grand jury. The grand jury decides whether they operated outside the lines of the Constitution or in the bounds of the Constitution to the person they detained or arrested. Okay? So really, this debate thing is what I'm having a problem with, because there is no debate on this. And by the way, right quick, none of these people, of any government officials, is actually signing the oath of the Article 6 4-101. The reason why they don't sign it is because they are bonded to the Constitution, and the ones they file in the states, they got a way out. It says Constitution and state laws. Alright, so they have a way out. So they always go by state laws and not by the Constitution. Well, Article 6 4-001 plainly, the only thing it says, and this is how simple it is, because I'm a dum-dum. I, blank, so swear to uphold the Constitution of the United States. That's it. No, so help me God. You know why? Because so help me God is a religious text in the government. All right? They're supposed to not. It's separation of church and state. There's not supposed to be. So help me God. Does it sound good with the religious people? Yes. Does it sound good for the unreligious people? I don't know. But the separation of church and state right there plainly just says them, they're not to have that oath. Well, that word itself on the oath. Now, it got changed and all that, and I understand why they did it and all that kind of stuff. But, again, the Article 64001 is they must take that oath first beyond all oaths. And then they can take other ones. They don't have to stop on that one. But they must take that one before any others.
The Supreme Court in the early 2000s decided a case in which they held that lower courts deciding whether an officer was entitled to qualified immunity had to do two things. One is that there needs to be a constitutional violation.
Do the actions of this officer violate a constitutional right? Yes or no? That officer may still be entitled to qualified immunity by virtue of the second inquiry, which is whether or not that right had been clearly established at the time of this now decided upon violation.
There needs to be a prior court case holding the conduct unconstitutional, sufficiently similar, in fact.
There had to be a prior court case, which is really, really rare, because that's the reason why it's so hard to get rid of the qualified immunity. The court case itself is going by not constitutional law, but civil law. So they just really extended the powers so it's more unlikely to be sued. Anytime you go into the courts, there's always a new case number. So why can't there be a new case law or case number when you proceed forward in these courts? They just ignore it. Where does it say that it has to be prior? It don't. That's the reason why every time you go to court, there's a new case law. It's to be put in the books. But on this one, it just stops right there. That's it. Is that extra protection.
Actual terms to the case before the court, that the factual circumstances of that case would inform the defendant that the conduct was unconstitutional.
If the answer to that question is no, I would give that officer qualified immunity, but at least now we know moving forward, if somebody does something like this again, it has been clearly established.
The Supreme Court explained that that process would help clearly establish the law in the future and give guidance to police officers and police departments about the contours of the Constitution. In 2009, the court said that it was unnecessary for lower courts, when deciding qualified immunity motions, to answer the first question. And that decision has allowed subsequent courts and the Supreme Court regularly to grant qualified immunity, holding that the law was not clearly established, without ruling on the underlying constitutional claim, meaning that the constitutional claim regarding that case remains undefined, and it becomes increasingly hard to clearly establish the law and get past the hurdle of qualified immunity.
And they brought up an interesting thing. When the Constitution is undefined, that means really there cannot be no law on it. Now what they do is decide to make laws because they haven't been. That's what keeps us more free. If it hasn't been on record, it's not to exist. There's a reason for it. You don't get to fill in blanks. Because when you start filling in blanks, you start destroying the Constitution. That's the reason why civil law came in effect. That's the reason why people brought up that, there is no Constitution in this president in civil law. Well, it's because it's not supposed to exist. That's another country's ideas that was been adopted in our country. We are a common law country. We'll proceed forward.
Courts around the country, there's a great deal of confusion about what clearly established law means. Can only the Supreme Court clearly establish the law? The Supreme Court recently said that they assumed arguendo that decisions other than those by the Supreme Court could clearly establish the law, but they've never come out and said clearly which courts can clearly establish the law.
It's important for officers to have qualified immunity so that they can perform the discretionary functions of their job without fear of liability. I have talked to many individuals who have told me that in certain situations they
All right, without fear of liability. No, they need to be in fear of liability so they don't arrest innocent people. They always need to be on top of the game. They always need to be cautious what they're going to be doing to we the people or public citizens, however you want to define yourself. They always should be on fear. But now they're fearless. They get to do what they want to do. Enhances what we've been having protests about here lately. It's because cops got to do whatever they want to do all the time without fear. I'm in fear of just in case I had to shoot somebody. They need to be in fear.
knew and recognized that they were entitled to use force, and they told me that one of the things that prevented them from doing so was the fear of being sued after the fact. That's a dangerous situation. Law enforcement officers must be able to do their job, including using deadly force if it's appropriate, without that fear of liability hanging over their head.
Absolutely not. They always need to be in fear of it. Always.
When I studied the frequency with which police officers contribute to settlements and judgments and lawsuits brought against them, I found that cities and counties that employ those officers pay more than 99% of the dollars in those cases. So the financial justification for qualified immunity as a shield against the financial burdens of litigation is simply untrue. The Supreme Court should reconsider qualified immunity doctrine because, as Justice Sotomayor has explained, it renders the protections of the Fourth Amendment hollow. When the Supreme Court grants qualified immunity to officers who shoot people without justification, who shoot people against the orders of their supervisors to stand down, it sends a message to officers and to society as a whole that officers can shoot first and think later.
Qualified immunity is not meant to put a roadblock to the courthouse for legitimate plaintiffs who have suffered a violation at the hands of law enforcement.
Actually, that's exactly what it's there for. That's misleading, y'all. That qualified immunity is exactly the opposite of what that guy just said. It is there to protect them from any liability that they caused harm upon us. That's exactly what it's for. It's to protect the judges, to be able to take our rights away, and nothing you can do about it. That's what it's specifically there for. And for the officers, the same thing. It is better to take our constitutional rights away from us than to be, I'm not even going to get into it. I apologize for that. But yeah, it's there intentionally to actually do the exact opposite of what they said.
The law enforcement officer did nothing that constituted a knowing violation or would satisfy a plainly incompetence or almost a gross incompetence level of misconduct, that person should not, that person being the law enforcement officer, should not have to defend what he or she did in the courtroom.
Absolutely should defend what he did. Absolutely should defend it. Enhances grand jury decides it. We've gotten away from this grand jury way too much with our government officials. All right? It absolutely needs to be, whether it's Congress, president, judges. I mean, we need to get rid of some of these judges. And yet they have this qualified immunity. The Bundy judge absolutely says there is no room for the Constitution in my court. And still a judge. So no, there absolutely needs to be a consequence. All right, this is Diesel for We the People. Hope you enjoyed this class and what I say. Excuse me. I don't have COVID, by the way. This qualified immunity's got to go. They need to be held up into a higher standard. And by the way, our Bill of Rights, if we really read it, is our qualified immunity. Think about that for a minute. They just don't get to do whatever they want to do. They don't get to, question the Constitution. They got to go by the Constitution. If it's not in the Constitution, they can't add or subtract. It means that law has not been established. Leave we the people alone. Or public citizen. They don't get to fill in the blanks. Alright? That's another story in another day, but that's exactly the reason why it is what it is. Is so they cannot add stuff to it, or it defeats the purpose of even having the Constitution if they get to go in there and destroy it. It defeats the purpose of having the Constitution if they make exceptions about the 14th, or the 4th Amendment about warrant arrest, no knock warrant? Really? No, we have this right. This blank thing, what they're doing is filling in and taking from us a CPS. Get to come in and check out your kids. The cops are all jumping up and the judges are saying, hey, you got to do this. You don't have a 4th Amendment. So, anyway, Diesel for We the People. Sorry about this being too long. If you want to just watch this twice and all that kind of stuff. Again, this was a learning video. Take it as you wish. Any name calling that I use, I was just saying as in general, what they are calling you. Not me per se. Till next time, Diesel with the People News. Bye.